All right, here we go.
I love
all
him.
the news that is
Such a
news
good
out
boy.
the seat at
Okay.
the supermarket.
So,
I don't want to
why
be just
even
another
have-
dead sailor.
Wow,
We're
that was
talking about
just a full-on
Kohberger.
repeat, like a
We
full-on
are starting
parrot.
again. So
No,
we
we're
already
not.
had a little bit going, but now we're just redoing this pod. We're talking about the Kohberger
Yes.
sentencing yesterday.
Yeah.
And you had some questions about that. And I was feisty in our first little get out the gate, and no longer am I feisty. Hit me with it.
No, I don't. Okay. Well, my question was my question back then was gonna be, I guess, does he have to speak at his sentencing hearing? You said no. Does he? Are we gonna find out anything else?
I said
You
I would
said
eat
no.
my hat if he spoke.
Right.
I said that his lawyer would
didn't-
have to be drug out back and shot if he spoke.
Yeah, I figured he probably
what I said.
wouldn't. He hasn't spoken much.
Right.
In fact, he wouldn't even give a plea when he was first arrested. He wouldn't speak. He would refuse to give a
Like an
guilty or not
interview
guilty.
right.
No, he wouldn't even tell the judge. The judge went ahead and just gave a not guilty plea.
Mm-hmm.
So I figured he's probably not going to talk, but I didn't know if he had to, maybe with this plea deal that was a sudden change of things. So, or that maybe they'd,
Well, I think you're onto something wherein your questioning all went down the same rabbit hole of, I want to know. I want to know. I want to know why. I want to know why. I want to know why. And this system that we have isn't set up for knowledge and isn't set up for you to ever know the why. You made mention of one of the victims' family members saying that she forgave him and here's my phone number, call me, I have some questions.
Yeah, when you're ready to talk, I will be ready to listen.
Right.
You can call me.
That's the smartest
No
woman in
judgment.
the courtroom.
No judgment.
That's
she
the
said.
smartest woman in
Totally.
the courtroom, because if he's ever going to, and I doubt he'll ever reach out, he's a little bit of a, from what it appears, he's got some issues, one would think. But at least that opened a door that otherwise might not have been opened. She's impressive to me.
Yeah, she looked to be the lightest souled person, because she decided that she was going to let go of that hate. She didn't like what it was doing to her family, her own family on the inside. They were, it was anger and.
Right. How interesting, huh?
Yeah, it was really impressive. It was for sure. And anyway, yeah, but I don't, I didn't understand why he wouldn't have to explain, or at least provide, well, if you did, prove it by telling us where the murder weapon is.
Yeah.
Prove that. Then
Well, right.
then why not kind of thing? Like, why would they just...
Well, when you witnessed the change of plea, which was not the sentencing that happened yesterday.
No.
The change of plea was when he said guilty to all the charges. Okay?
Right.
There was what was called a factual basis. Okay? So this plea agreement that we're discussing right now is called a stipulated plea, meaning the judge can't do anything with this agreement. He can accept it or reject it. That's the only thing he can do. Okay? It's either a ball or it's a strike. He did accept it at change of plea. So therefore, the judge is just basically sitting there listening to all the victims tell them how terrible their lives are going to be, or get to hear that gal and how, kind of an inspiring individual. But bottom line is that's cathartic for them to speak on behalf of their loss and their victim.
So it's just part of that process that you and Jesse were talking about? Like, it's just that next step that has to happen type
Yeah,
thing?
me and Westover just did a pod, so check that out. That's going to be a good one. But yes, that's part of the process that we talked about. But not every plea is like that. That's what we call a stipulated plea. But most stipulated pleas have some wiggle. Okay? This one had
what
none.
that means,
Okay,
wiggle, because
I will.
the stipulated pleas, what you're saying is that the prosecution and the defense already agreed privately on a specific amount of time, one like a flat piece of time, not a range.
Right.
Or
Okay, so yeah.
Okay.
So this is a stipulated life that you can only have so many lifetime periods.
Right.
And so this sucker's going to be racked up for life. Mm-hmm. And so probation isn't up in the air. Parole isn't up in the air. There's very limited appeals that can be done in this circumstance because he entered a plea. So your appellate rights are kind of cut off, a lot of them. You have a lot of appellate rights when you go to a trial and lose. You can literally appeal every sentence that was said during your trial. I'm not saying that you're going to win. Most likely you're going to lose. Most appeals do. But at the end of the day,
you can waste that time or spend.
You spend that time just being anxiously engaged in and chasing your appeal because you ain't got nothing better to do.
But I think he in particularly agreed not to appeal.
Well, there's one appeal that he can't waive and no one can waive, and
what's that called?
That's the
he can't. There's one he cannot. They cannot put in writing.
No, they can't put any appeal in writing. Whenever I heard that, that's just poppycock. He entered a plea, and so when you enter a plea, your appeals are pretty much you're waiving them already. That's by virtue of signing a plea.
Okay.
But there is one called ineffective assistance of counsel, a Rule 32 or 33 here in Arizona. I don't know what it would be in Idaho, wherein you can do a post-conviction relief. And it's a very short period of time where you have to file that.
How long?
Here in Arizona, it's 90 days.
Okay. I mean, Ann Taylor, who I'm wearing Ann Taylor pants today, but not the same Ann Taylor.
I'm not.
However, Ann with an E Taylor has been setting up an ineffective account. I mean, she has been saying, that's all she has been saying to this judge has been motion after motion. We are not prepared. She's called herself ineffective counsel. Is that, ineffective counsel if they went to trial.
I have a hard time thinking he's going to exercise that post-conviction relief.
Okay.
But I do remember you telling me that and seeing a little bit about that. And that is a very dark place to be when you're in her shoes, when you feel like you have to prepare for the world, and frankly, she knows things that we don't know and always will. There isn't a spill your guts time. The spill your guts time was when they read what's called the factual basis. So they read that line item per line item per line item per line item. How do you plead guilty? So you're going to get yes, no. And so you're not going to get, what was on his mind, what was on the radio on his way there, what started this whole thing, why did he start to want to be bloodthirsty or do things like this, why this house.
That's what I was wondering.
There's going to be a lot of
they found no connection.
Right.
And so I guess I've seen Datelines, and where real people have done plea deals kind of last minute or that saved their lives type thing. And then at sentencing, at least I thought I was sentencing, they gave a recount of what they did.
That's a change of plea.
And so, but they gave the recount.
That's a change of plea.
In his own voice.
Well, that might have been that person in prison.
I'm saying
for television purposes.
So they never. I don't think it wasn't like it was like these people were telling the judge what they did.
I've been about this for 20 plus years. I ain't never seen that. I ain't never gonna. So it's not TV.
I'm just saying that I've seen these things. These real things to talk about. They confessed to what they did.
They're obviously not
in
real.
exchange for a lesser sentence type thing.
Maybe that's what we call an interview with the law enforcement.
No,
that can happen there. Okay. It's not a court function.
Okay.
The court is an adjudication arm.
No, but it was agreed upon by the parties privately that they would give a recount of what they did.
Who agreed on this?
Just some cases I've seen that, like in the things I've
I guess I haven't had the pleasure of having a case like that.
Where the prosecution and the defense decided that for a lesser sentence, if they'll give up where a body is or where.
Oh, I've had for lesser sentences they give up another drug dealer.
Yeah, I guess I'm not trying to argue with you or be.
I'm just
telling you what I'm
trying to follow this. This is kind of interesting because I'm trying to live in. There's a movie world and then
it's
the
not
real
that.
life.
It's like, I'll find a example. I didn't realize I'd have to find an example to get you to. It's not about movie world or Dateline even. It's just about where I know prosecutors can, at least they have that ability to require that if we're going to take this off the table, we require that you.
Well, the prosecutors are under no obligation to offer a plea, and that does happen. Sometimes.
So they just did that on
They're under no obligation to offer a plea agreement. They can try every case through their office, should they wish. Defense attorneys also don't have to accept one thing.
They don't have to, accept.
And so, not the defense attorneys, but the defendants don't have to accept one thing. What is being lost in translation, and I'm getting caught up on semantics, and I don't want to get caught up on this tripwire because I think you have so many really good questions about what a sentencing is, and that it would be important to kind of go over those things. But what I want to do is just say, okay, well, here we have a change of plea where all the facts come out then. Sentencing is a time wherein the judge can determine what is the proper fit in some of the things the judge has discretion on. So the judge might have discretion in this or that. This wasn't that situation.
I understand.
The judge didn't have any discretion on anything because a life is a life is a life is a life. There is no parole. There is no probation. There is no, he didn't have to weigh in on the death penalty. So really this was a moment in time for the victims to say their piece, but it was literally not necessary because the penalty already was going to be what it was going to be. None of that had to happen. But some people want to speak. It's because it's cathartic. In most plea agreements that aren't a quadruple homicide, super crazy scenario, most plea agreements have moving parts. Okay. Some plea agreements have, you can serve, your client may serve 4 years and it's arranged to 12 years.
And then the judge decides.
And the judge decides between 4 and 12. And so, now you're bringing it. Now you're bringing the mustard as to why the judge should go 4, and the prosecutor's saying why the judge should go for 12. Now, a smart prosecutor will not hit that 12 mark. They'll look super reasonable, knowing the defense guy has to say 4 because he's, we got a client that obviously wants to spend as few minutes in prison as possible. But a smart prosecutor hits that 10 mark or that 9 even. Ooh, and they're going to get it a lot of times. Not every time, but man, that's just a very bright move. Had a few prosecutors that have been very bright, and you've got to really know who you're dealing with and know that you're going to end up with brightness because you're going to need to make up for that somewhere in that.
Show why it should be 4 and not.
Right. In that sentencing, you're going to have to.
Where they're being generous.
Where they're being reasonable. Right.
Where,
That's way more powerful in a judge's eyes than generous or nice. This reasonable word, this respectful word. Ooh, that's carrying a big stick.
And then going for the jugular.
Yeah, they could, and the judge knows that. And so, judges too are also human. So some of the better questions that you had were, I'm not going to know this, I'm not going to know that. So why is the family saying all this stuff? Well, it's for their own benefit. It's not going to enhance the in this scenario. It wasn't going to enhance the penalty. In other scenarios, it does. So like I said, that 4 to 12, it starts pushing it closer to that 12 mark because that's, there's been some real damages done and the debt to society should match that 12 number. or conversely, other types of statements, meaning by a defendant, like Kohberger was here, a defendant speaking on their own behalf and saying, this is what happened and this is what I've done to remedy. And so many questions are answered in that scenario. This is what I was accused of, but this is really what happened. The facts are these. The story shakes out this way. But usually that's done in quite a bit of motion work, and then you're just dealing with a little bit of nuance there. Showing, hey, client had an addiction problem, and as we sit now, is sitting here with with 392 days clean, because of these efforts that he's that he or she has done. So,
okay,
that's kind of how that works. But all of it, that's a
yeah.
sentencing.
So it's just decorum or a formality of for that.
Yeah, and to see somebody's eyeballs, to see somebody's eyeballs right before they go into prison, that's a unique experience that you can't wipe that off. So, as far as this sentencing and the procedures and all of these things, that's the entirety of what you're working on from day one. Is, okay, where should this land? Is this person guilty, innocent? And what's the evidence and where's the leverage? Most of the time, when somebody is accused, most of the time, not all the time, there is a guilty flavoring to this. But of what? Okay, what exactly is, how deep's the water? And once you find that out, where's our leverage? Where are we strong? And where are we weak? And let's be aware of both, and let's work this case. And let's start a playbook. Let's start going towards our goal. And our clients are literally our best asset, because they're our shiny car that we're trying to sell, or they're our jalopy that we're trying to sell.
Is this type of offer or plea deal common? This close to a trial?
Yeah.
Is it common in the beginning of a case? So in the beginning of this case, if you were to hear that he was offered the same deal and it was refused,
4 to 6 months in and on and beyond that, yeah, it would have been very common. 4 to 6 months in.
Quadruple murder.
Yeah, 4 to 6 months in, yeah. But when you've got a quadruple, you got to think of it interestingly different. You got a quadruple homicide, you're not a whole lot to lose. There just ain't a whole lot to lose. And people might argue that, well, his life. And okay, I don't really know if
you mean as the defendant? As a defense?
Well, he has his life to lose because there's the death penalty. But, I wonder, with somebody wired in that regard, how important that is to them. I just don't really know. It seems like life and death is viewed differently by the individual in question here. So what kind of carrot does that have? What does have value to this individual? I don't know. Maybe it's mom and dad. Maybe it's...
The rumor was his mom said no in the beginning, and he asked his mom, and then the second time...
She said, yeah.
She said, yeah, she agreed that, I mean, I to be honest, if I was his mom, I don't know that I would be on board. I don't know that I would have accepted that at that time either, 6 months in, or even a year. Accepted that this is the reality. I would probably, I don't know. You know what I mean? I don't know.
Yeah, it's hard to call balls and strikes as
he's
mom.
He's 27 years old, too. He's a grown man.
Yeah.
As
mother, it's always going to be hard to call balls and strikes. I mean, there's an emotional component that gets in the way there.
But the fact that he cared what she said.
Yeah. And obviously a good emotional or a strong emotional component if he cared, because that means that he's got a connection there with mom at a minimum. So.
Yeah, I don't know.
I don't
I think
really
they're
know.
pretty close to their family. I think he was close to.
Well, he was there
family.
visiting when he got picked up, right?
Yeah, his dad flew all the way across this, from Pennsylvania to Washington and drove the car back with him.
Oh, okay.
That had been planned for months before. And then, he was stopped a couple times during it. They have they're following him. For some reason, I didn't understand that part, but why they would follow him they knew of him. I think they had the dad's thing by that point, the dad's information, the partial DNA. And so they honed in on him, but on Kohberger, but they followed him and stopped him a few times halfway through. I don't really get that part.
I don't either.
Like why they would do that.
Yeah,
they have they show the videos, the body cams and stuff of that.
it's interesting.
Mm-hmm. Like 2 in a row and then another one maybe a couple days later, because it's a long road. It's a long trip.
Oh yeah,
She has 2 sisters, 2 older sisters. That one's a psychiatrist who went into.
Interesting.
Who went into it, I think, because of her brother.
Okay.
Of the struggles he had and.
Oh, because of the struggles he had prior to all this.
Yeah, I mean, he's had some, major OCD,
Interesting.
What is that? Asperger's.
Asperger's is what they were saying. He's on the spectrum somewhere.
She's some kind of psychiatrist or neurologist, something with the brain. Yeah, because of
behavioral something.
Behavior, yes.
And the other one is.
I think she's an actress.
Right.
Mm-hmm. but it's just a very normal family. But his dad was a janitor, and stuff at his high school, I think. And
interesting.
Worked really hard for.
And my grandpa's a janitor for Mesa High School.
I mean, the guy he failed out of high school, but then.
Mesa Public Schools, not Mesa High.
Yeah. Oh, that's so cute. I think that's cute, but. So I know. I mean, he was able to put himself into, to become a real academic, and get himself through
Yeah, I mean, he was
all kinds of
pretty far down the road in academia, and it looked like that's where he was going to just end up.
He was picked. He was recommended by Catherine Ramsland, who's one of the top four criminology experts in the world. Recommended by her personally to this fellowship at this PhD program.
Yeah. That's very interesting. So what other questions do you have as far as procedure goes?
Yeah.
Because you got your change of pleas. So just so we can have a little recap, you have your change of plea. That's where you say guilty to a certain set of facts. Okay. That's usually the only thing you have to say as a defendant. Now,
do you understand what you're saying?
If it benefits, right. You understand this, you're saying guilty in your own free will. They go over warnings after warnings after warnings. You've understood this, you've read it, your lawyers read it to you, everybody's read it to you. The good Lord came down and hit it off the trump, and this, that, and the other. Can
I have that water on your seat, by the way? I meant to ask you. That's what I came down for. I went up to go. Thank you.
And so did Moses part the Red Sea and read it to you on your way from dry land to dry land?
Yes.
And so that's that time. Then you have a very important time of... Then you have a more important time that is the sentencing. In the sentencing you have... Most aren't lifetime sentences. So you've got a probation summary report, which is probation does a report on you. They do an interview. Then if you have an attorney, which is always a great idea, you have what's called a settlement conference memoranda. A lot of inmates and a lot of other people call it a mitigation packet. That is slang. It's not really called, well, here in Arizona, it's not called that, or at least it's a settlement a sentencing memorandum. Defense sentencing memoranda should be pro-defense, where you're putting in all of the information as to what's what your arguments are for the lightest sentence possible. Sometimes the lightest sentence that you're going to get is less probation thereafter. So let's say that your client's going to jail for 2.5 years. Well, now you're arguing not to have 5 years probation tail on there. You would rather it be land somewhere around 2 or 3. That would be a little bit easier, less ornery, less burdensome for your client. So on and so
Makes
forth.
sense.
So,
Okay.
I mean, that's really
So
what
on
these
and
are for. There is a minor back and forth. Oftentimes the state will defer when it comes down to, or take no position when it comes down to just probation. They already feel comfortable with their amount of years that they got and da-da-da-da. But if it's not an agreed upon amount, now you're arguing for the state has their recommendation. It takes literally a couple of minutes for them to recommend it and the reasoning for it. And it's never the defendant didn't show us where the knife was. It's never the defendant didn't open up about this, that, or the other. It has zero to do with that. It has everything to do with the facts at large. Does that make sense?
Yes, it does. So, okay. And then the defendant can speak if he wants.
Yeah.
And he does not have to if he doesn't.
Yeah, and if, look, in that scenario, most of the time you want the defendant to say something to the judge. Most of the time. There's very few times where I'm like, I mean, I'm like that every time, honestly, but...
what makes you not want them to speak?
I'm going to say something stupid.
Their demeanor, their personality.
Look, it's... Every defendant knows when they're in that situation, knows that they did something wrong, but feels a little bit of shaft. And you just don't want the shaft to come out right there in sentencing. And every once in a while, that can and has happened. Now, you've got to be able to skirt that quick. But for the most part, that doesn't happen. For the most part, they're just very, gracious to the judge, and they should be talked to about what this means and how important it is, long before they're standing right in front of the judge.
Right.
But inevitably, you have people that just start talking, and you can't stop them. And that's when you have.
Do you have some in mind right now? That's when you have what?
That's when you have safe words.
Like what?
And little things where, look, most of the time I'll just cut them off. And I think we've heard enough from my great client here, so on. Most of the time that would be how that would have been handled back in the day. So,
okay.
Kind of one of those cartoon type things where you see the what is that, the cane where they yank them off the stage.
The hook.
Yeah. And I have a piece of paper there, and I'll just write, kindly shut up. You're done.
Perfect. You're done. Yeah.
Right.
Okay.
Wrap it up.
Yeah. Perfect. Okay. That's interesting, I guess. I'm wondering about any stories you have. Your favorite story.
I have all of those stories.
I have all the stories.
No, my favorite story I just said on I don't know, favorite. Probably the ballsiest, the most humbling time was when I said nothing in the sentencing.
We just talked about that.
And we just talked about that, and I
frankly
hadn't even remembered. I brought it up a few times here and there with when you get to thinking on whatever. But this has been a few years back, 4 or 5 years ago, and 4 and some change years ago. When I was doing the trial thing a lot, we were doing a sentencing, which was a very ugliest case you can probably have, absent, murder, but in some ways this is probably worse than that.
Yeah.
And I had a bloomin', like I said earlier in this pod, most of the time the state is 2 minutes or less. And the defense is the one that has to have their mom talk on their behalf, or their wife, or their Aunt Bunny, or their boss's sister and their frog, and all that. I mean,
and their frog.
Like, people want to talk on behalf.
Interesting.
And we'll run traffic on that. And we'll say this person, keep it under 30 seconds. It's really not going to. It's not going to change the needle.
Yeah.
The judge knows that you know people. The judge knows that no matter if you're the Grim Reaper, the judge is going to know that someone likes the Grim Reaper. The Grim Reaper has an Uncle Buck that is going to say nice things about the Grim Reaper. So it just happens to be the case. That said, what changes the needle is certain things that you begin from the beginning, and you work those things, and you work those things, and you work those things, and you work those things with your client to where when you're at the end in this sentencing, you have things that do change the needle. So I had a 4-year and a 12-year. So it was a what we call a range. And
you're saying a 4-year minimum.
4-year minimum.
12-year maximum.
The judge could fine for 4 years. Judge could fine for 12.
Or anywhere in between.
Anywhere in between. Deuces are wild. Anywhere in between, right there. But not any more than 12, and not any less than 4. Okay, so he can't aggravate, and he can't mitigate. It's 4 or 12. And that's a miracle range for this case.
That's a big range number. That's a long time.
It's a little bit of a range. I mean, I've seen bigger, but that's a good size range. I mean, 4 years. But it was a miracle range because it could have easily, this particular case could have started at 12.
I understand. I
was pretty impressed with us being able to whittle that down. But the prosecutor was bent on double-digit numbers. He wanted 12 years, and he was an hour and 47 minutes long with a video of all the evidence that, frankly, should only be watched predominantly in camera, which means in private. Myself, him, with a deputy oversight. That's called in camera. So you can own that evidence, cannot leave that room because the evidence is illegal.
Right, I understand.
Okay, so we're there, and he's kind of got like blocked, some
Blacked
images blocked out and this, that, and the other, but you're getting a pretty graphic showdown. And he's trying to piss off the judge. I'd been in front of this judge quite a bit. I hadn't had many cases with this prosecutor, but I did not like him. There was not good blood between us. And I still don't like him. I still think he's a jackass. But that said, I don't.
Right.
And so.
Well, I don't blame you.
He went on and on, but then I see the judge kind of yawning, kind of sinking down in his chair, kind of fiddling with some things. Not really paying attention to what was quite a bit. And so I'm watching this judge, and I know this judge. I've been in front of him a lot. This was a Pinal County case, and they're good judges over there in Pinal County. They have some good judges, good lot. Lovely bunch of coconuts. And so I'm watching the judge, and finally this dude ends. And and requests the 12 years and says it's a gift and all blah 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 blah. And he looks at me and he says, "Mr. Hogle, you."
The judge does.
Yeah. Anything further from the defense? And usually it's just my turn. After the state goes, we go. And I just said, reading the room, I said, "Did you read our sentencing memoranda?" And he said, "I did, every word." I said, "Then we rest." And he said, "Thank." It was so funny. I'd never heard. And then he pronounced the sentence right then, and then he went back to doing the proper procedure of things. He said, "I'm going to fine for the minimums," and it took the air. Awesome. Usually, you're sitting there holding your breath.
Yeah.
The whole time where they're going through everything they got to get through, and then he went back and. The prosecutor started packing up, pissed off right then. And he said, "Where do you think you're going? You're going to hear every word I have to say." It was pretty funny. It wasn't funny. It was kind of humbling, honestly.
Yeah, it's nothing to celebrate.
Yeah,
likely,
it was humbling, but it was a very, very good result. It couldn't have happened to a better man that's really committed to turning some things around. And so I root for him. And I still do. I mean, he just called me when he got out of prison. He'd been out a week. He gave us a call. and he wants to do everything by the book, much like he did his case. And so I'm pretty excited to continue working with him. It'll be cool.
Yeah.
But that's what a sentencing is. And that's the impact that a sentencing can have.
Okay.
But in this particular scenario with Kohberger, there wasn't a whole lot of anything that really could be. I mean, people will still do the podcast thing over it.
So they just had it just so the victims could speak?
Pretty much. I mean, it was all, there was nowhere it could go but the way the judge ruled.
Yeah.
I mean, it was going to max out no matter how you slice it. He was going to max out that plea. There was going to be zero, mitigation, given the 4 deaths and all the blood and guts and horror on this thing. So yeah, it was going through the motions.
Okay.
And you get to see it's not going through the motions for those people.
No.
I mean, that's very real for them. But they've been they've had a camera in their face for the last 2-3 years, 4 years, a long time.
4 years, almost.
I mean, that's a long time.
Yeah.
Oh, your nails look cute.
Thank you. Just got them done. So glad you noticed. It's cute.
Well, it hasn't been that long.
No, it's like 1 day.
Okay, I'm not that far off. Good. So anyway, that's pretty much the procedures and policies. What else you got?
Well, no, I guess to contrast the minimum story, you've had that go the other way too.
I have had that go the other way. I haven't had it go the other way maxed.
That's amazing.
I've never had it maxed. Interesting, oh boy. I had a kid that shot in a school zone, hit 3 9-year-olds with a shotgun. I worked that down to 9 years. That's single digits. I worked that down to 9 years, which is amazing.
Any
it
of
was
the
a
kids
gang
die?
case. No, none of the children died.
Good. That's
and they weren't dramatically wounded either. But they're still injured, and there you go. And it's a school zone shooting, and it's a bad day at Black Rock. But my client was a kid too. I mean, my client's 15, almost 16 years old. So, dumb kid, gangbang case. So we have the gang enhancement. And this wingnut's flashing gang signs at his sentencing, literally to his girlfriend, flashing gang signs. And the courtroom gets emptied, and the judge and I and my client and the prosecutor, who agreed to the 9.
Wow.
I know. This was a lot of work on this case. And the judge says, we're not doing this today because I'm too angry.
Yeah.
And so we had to come back the next day, and he gave him 11 years. We were set up for 9. So he just basically added 2 years to his, it could have been 23.
No, so that's still...
It was still a great deal, but he just added 2 years for being stupid. So I flipped that one. And then I had one that there was a death in this case. And the tippy toes on that case was 23 years as well.
Wow. Oh.
I had a plea agreement for 10. And I kept trying to get the client to pay attention to the evidence involved. Just really needed the client to look at that evidence, look at that evidence, buddy.
Look at what you did.
Because the 10's it's a gift. And I didn't love it, but given the circumstances, he needed to love it real quick. And the judge racked him for 17.
But he wouldn't be, because you're saying he would not, the client would not
he didn't
agree.
He wouldn't take
and he wouldn't look at the evidence.
Right.
Or see what...
Right. And so he agreed to a no agreements because there was no disputing guilt or innocence on this one. And so he agreed to a no agreement so the judge could go all the way take it from 3.75 to 23.75.
That's huge.
It's a huge range, right? But that's
gave him 17.
That's what the statute will call for there. So basically 4 to 24 is what it is, and the judge slapped him with 17, which is what I was fearful of. Yeah. That's been one of the bigger cases that, as far as time goes. I mean, we've had some lifers, and we've had some murders, and we've had some, but done some pretty good work in those scenarios too.
Oh yeah.
And
I've
so,
seen it.
but it's always been fair. In my opinion, they've always been very, very just straightforward. It sometimes takes a lot more effort and stress and anguish to get there. But so these sentencing hearings can be your trial. They're most people's
It's a
trial.
character trial, basically.
Kind of. It's basically, what are you going to do? You know, do you pick door number 1, 2, or 3? I mean, the judge has, some sway. Oftentimes, there's not a whole lot of moving parts. Sometimes there are, kind of like the ones I just described. A lot of moving parts. There's a big difference between 4 years and 17 years.
Huge.
And so that's a lifetime difference.
Do you think the judges make a decision before they come into that sentencing hearing?
Oftentimes, yes. That's why I talk in terms of moving the needle.
Before.
Am I going to be able to move the needle? This is how am I going to move the needle?
Where the needle's resting already. Do you think they're ever moved in those hearings?
Not always, but
obviously the 9 went to 11.
Right.
Or,
I didn't blame the judge on that one. I wanted to wring my client's neck. How hard it was to get it. And his poor family, his poor parents that were sitting there.
Ugh.
I wanted to wring that kid's neck. Just saying.
It's interesting. Okay. Well, thank you for your answers and your knowledge.
Knowledge.
How do you outro?
Knowledge. Knowledge is what brings us together today.